It is October 8th, and we are the Board on Professional Responsibility. We're convened here in the matter of Lawrence D. O'Neill. It is board docket number 19-55, disciplinary docket number 2018-D113. At this point, could the parties identify themselves for the record? Let's start with the respondent. Mr. O'Neill.
Yes, Lawrence Daniel O'Neill.
Thank you.
And Julia Porter on behalf of Disciplinary Council.
Thank you. So we're here on the respondent's exceptions. I assume you'll go first, Mr. O'Neill?
Yes, I would. Excuse me?
Just a few housekeeping things first.
Okay, fine, yes.
You've got 20 minutes. How much would you like to reserve for a rebuttal?
I'll reserve 5.
5
Okay.
minutes for rebuttal. And then one other thing, as everybody is aware, we're of course, because of the pandemic, on Zoom. So a couple of housekeeping things with that. First of all, Zoom does remarkably poorly if 2 people are speaking at the same time. So if you're arguing, if you could try to be mindful if a board member has a question, we will try to raise our hands like this to get your attention. But if you can try to look out and be aware of that, I'll try to play traffic cop with that a little bit. And second, for everyone, board members and parties alike, if you could be muted when you're not talking, it'll keep background noise from coming in and making things challenging. With that, Mr. O'Neill, you've got 15 minutes. Please start when you're ready.
Okay. My objection is fairly straightforward and very simple. I believe the record as recorded at the hearing is not valid or inaccurate in many respects. There were perjured testimony by Mr. Fusco and ambiguous testimony by Mr. Walsh, which I object to. But more importantly, as a matter of principle, I believe the determination of my role in this matter was incorrect. I was acting as a favor for a friend. I acted to help his brother, who I barely knew. And I did this as a favor, not as a legal matter, and never did act as an attorney in this matter. On that basis, I believe that the proceedings are invalid in that none of this related to activities that I undertook as an attorney, because I was not acting as an attorney. I could not have been acting as an attorney in Ireland, and never held myself out. In fact, specifically, which was part of the perjured testimony of Mr. Fusco, specifically and repeatedly held myself out to his brother and to Mr. Fusco on the basis that I was not an attorney licensed in Ireland and could not provide legal advice or legal assistance
Mr. O'Neill,
in Ireland.
Mr. O'Neill,
Yes.
may I ask a question? So
Sure.
if you were not acting as an attorney and you were doing this as a favor, which is something that you just said in your brief says, why did you take funds that you labeled as legal fees?
Well, they were mislabeled. It was a fee for my time and effort that I spent doing it for him. I spent a lot of time. Originally, let me back up. Originally, this was to provide advice to Mr. Fusco on negotiating with his adversarial partners. I had had a falling out, and I made some suggestions to him, which were accepted by him and which he followed. And he then asked me to get more involved in discussions. I declined to do so. I never did negotiate with anyone on his behalf because I declined to do that, but I provided him with more and more advice. The legal fee classification was a mistake. It was basically a minor compensation for the number of hours I had spent on this matter that I had no intention when I started of doing. I'm sorry.
Mr. O'Neill, is part of this representation of Mr. Fusco, did you not review at some point the agreement that Mr. Walsh drafted up between the two parties and provide opinion on the merits of that agreement to Fusco?
I did not. I specifically said that I was unable to Mr. Fusco, contrary to his testimony. I specifically said that I was not able to make a judgment as to the validity of that agreement under Irish law. He read it and accepted it, but I did not have any role in drafting it or in approving it or in signing it or in any other matters related to it. And I specifically instructed Mr. Fusco that I could not, because I was unable to give him an informed opinion as to the veracity or the enforceability or any other aspect of that agreement under Irish law.
Mr. O'Neill, similarly, at one point, was there not an email that you drafted explaining that it would be malpractice for you to provide certain recommendation to your client that the parties take more time to close this transaction? When you say malpractice, does that not suggest your professional responsibilities as a lawyer? What malpractice would you have been referring to in that instance?
Malpractice can have many meanings, but malpractice in the sense of my advice to Mr. Fusco as a business person would have been basically to allow him to advise him not to continue to demand the payment that was due to him. I was not in a position to do any of those things on a legal basis. That would not, indeed, the phrase was badly used because it wouldn't have been malpractice as an attorney to advise him to wait. It wouldn't have been malpractice to advise him at all. It just would have been wrong, as the word intended to use and probably should have used would be wrong.
Mr. O'Neill, your correspondence throughout this, though, however, refers to your company, if I recall, as legal advisors.
Yes.
It refers to your license to practice in Maryland and DC and in the Supreme Court. You sign your name with Esquire and your bar number and all of those things, and then you charged a legal fee and you referred to malpractice. Are you asking that we disregard all those indicators that you were doing legal work, the bar number, the legal advisor, all of those things, in order to find that what you were doing was not legal work?
Yes, I am. And there is no bar number on that. Let me give you the basis for the correspondence. Basically, legal advisory work that I provide is to companies all over the world in many jurisdictions where I am not admitted to practice law. And so the term legal advisor was specifically added to that letterhead to make it clear that I was advising on legal matters, but was not, in fact, acting as an attorney. The admission statement on the form was done several years before, because I had a discussion with the Law Society in Dublin, where someone had raised the issue with me informally about whether I was practicing in Ireland or not. And I said, no, I'm not admitted in Ireland. And it was meant to be exclusive, not inclusive, when I put it on there. It was to limit the scope of where I was admitted, not to expand it. It was not designed to imply that I was admitted anywhere but in those jurisdictions. And I did it at the request or at the behest of the Law Society, which accepted that as a legitimate way to make it clear that I was not admitted to practice in Ireland. It was not acting as an attorney in Ireland. The bar number was never on the documents. There is on the document, as required by Irish law for a company, there is my Irish company registration number, which I did include on the form, which is required under Irish law.
I understand that, but legal advisor, I'm trying to figure out what the difference between a legal advisor is under your distinction and what a lawyer is, because a lawyer gives legal advice. They're hired by people to give legal advice, to assist with negotiations, to review documents, to, as you said, give advice in this negotiation that Mr. Fusco was working on. And so So where are you drawing the line between the advice you're giving that is legal advice that isn't advice that a lawyer gives?
Well, the distinction in this specific case was that I was not giving him any advice on Irish law. I was merely giving him advice on negotiating this agreement. I have a lot of experience, extensive experience, 40 years of experience in negotiating contracts and agreements, and I provided him advice on those negotiations. It started off and was throughout the entire process, by the way, as a favor to a friend. Yes.
Mr. O'Neill, though, sorry to cut you off, but ultimately you take the funds, your client's funds, and you put them in your lawyer trust account. So if you're not acting in the capacity of lawyer, why would you take a client's funds and put them in your trust account that is designated to hold your client's funds in trust related to a legal matter? Can you explain that?
Yes, that was, well, it was done at the request of Mr. Fusco, who wanted the funds to be removed from Ireland. And it was a mistake, and I shouldn't have done it. It was an error of judgment. I shouldn't have moved them, but I did. And I didn't move all of them. I moved some of them, but I shouldn't have moved any of them. Mr. Fusco was concerned that if I left them in an Irish account, that it would be that the Irish tax authorities would want some of that money.
So
That was the wrong thing to do, and I admit I shouldn't have moved him into that account.
I believe Ms. Larkin had a question.
Yes.
Right, and you're muted.
No, it was asked.
Ah, okay, great. Sorry, carry on, Mr. O'Neill.
Okay.
I have a
the-
question. What is
sorry.
the current status of the funds right now in terms of the return of the funds?
Okay, well, the funds have only recently, I mean, literally recently, as in yesterday, been sent to my solicitor in Dublin, Mr. Martin Moran, and I have asked him to communicate to Mr. Walsh and to come to a resolution, a settlement, a payment on the matter. I think there's some interest due on the funds, some statutory interest. I'm not exactly sure what is due. I have wired this morning. I've been waiting for months and months for a fee, which I just received on Friday of last week, and which just cleared on Tuesday, and have sent those funds to Mr. Moran to settle that and a couple of other things in Dublin that need to be settled and paid.
So, Mr. O'Neill, you don't dispute that you took funds that were your client's funds, put them into your IOLTA account, and used those for your personal use. Do you dispute that?
I dispute that. They were not used for my personal use, but they were used. They were not. First off, I dispute that Mr. Fusco was a client. He was a friend, the brother of a friend that I was helping.
So let me rephrase then.
Mr.
So you took
Yeah.
Mr. Fusco's funds,
Right.
regardless of whether or not he's a client, put them into your IOLTA account, and those funds were dispersed for matters unrelated to Mr. Fusco's matter. Is that
That's correct.
accurate?
That's correct. That is
So-
accurate.
And you're disputing that those are used for personal funds because why?
Because they were used to pay legal fees for a gentleman, Andrew Krieger in Germany, who was on trial for various things, and his fees needed to be paid, and they hadn't been paid. And his lawyers had down
Mr. O'Neill.
tools.
Mr. O'Neill, are you disputing that Mr. Fusco did not give you authority to take his money and pay another person's legal fees?
No, I'm not
Did you have the
disputing that.
authority to do?
No, I did
Okay,
not.
so you agree? Okay. So.
Mr. O'Neill,
you-
I'm sorry, Margaret. Go ahead.
No, go ahead. Go ahead.
So, Mr. O'Neill, Mr. Krieger was a personal friend of yours, is that right?
Yes, correct.
And you wanted to personally assist him in his legal effort, correct?
That's correct.
And so you had a personal purpose in using those funds to assist your personal friend, isn't that right?
Well, it was more complicated than that, but yes, Mr. Krieger needed funds immediately, and I had been promised funds. Another part of the incorrect statements. I had been promised funds by a gentleman that owed me and Mr. Krieger 200,000 euros, Mr. Raja, and he promised to send them, Mr. Krieger needed legal representation. It was the wrong thing to do. I'm not saying it was the right thing to do. I'm saying it had nothing to do with legal matters, a legal practice or legal representation. The funds were there. Mr. Krieger was in trouble, and Mr. Raja was confirming repeatedly that he was sending funds to me and to Mr. Krieger to which could be used to pay those fees when they didn't arrive, and his German lawyers resigned unless they were paid in the middle of a trial. I wrongly used those funds to pay legal fees for Mr. Krieger.
So, Mr. O'Neill, you keep.
Mr. O'Neill,
Oh, sorry, go ahead.
sorry, that's okay. Mr. O'Neill, you said that yesterday you sent funds through your attorney to someplace or through someone
To Ireland, to the account of Mr. Martin Moran, who was my solicitor in Ireland.
So how do we know that to be true?
I can, when they're received, I can provide, Mr. Moran can provide a statement that he's received the funds.
Neil, that sort of leads into another kind of question I have about your brief. You've got a long discussion of a number of, I guess, facts that you would like us to find, maybe, but none of those have cites to transcripts or anything in the record. And I'm not sure how we adopt those findings or make those findings without some kind of factual record below. I mean, we can't just take your brief before the board as an affidavit, and when you haven't, been cross-examined on that brief, or I'm not quite sure what we're able to do with those factual assertions, or what you want us to do with them in light of the lack of support they seem to have.
I'd like you to take those factual assertions as my factual assertions and to act accordingly. I don't believe that this matter is appropriately before the board. I believe it's a matter between Mr. Fusco and myself. And it was a business transaction. It was nothing to do with a legal representation or law. It was a bad thing and a wrong thing. I have now at last, and belatedly, I admit, because I just didn't have the funds, because the various funds that were promised were not delivered. It was only as of last week that funds finally became available to me, and which I have forwarded to Mr. Moran. I'm happy to have Mr. Moran provide an affidavit, but that's I can't say more.
Mr. O'Neill.
Why don't we hear from disciplinary counsel? Sorry.
Yes.
I was just going to ask
Yes.
one real quick question, if that's okay.
Sure. Yes.
So your position is that this was not lawyer work, and thus the rules do not apply. But many of these rules do not require that you have an attorney-client relationship. The 8.4B larceny and theft, the 3.4 knowingly disobeying an obligation of the rules of a tribunal. I can go on, there's others. What authority do you have? Can you point to any case law or anything that says that we can't apply the rules of professional conduct in a situation where you've acknowledged you took money that belonged to another individual and then used that money without authorization for well over 4 years? Do you have authority that says that we can't apply the rules in this context?
I think I've cited authorities in my brief that basically say that the jurisdiction of the DC board is limited to actions taken by a lawyer and taken within DC. That these matters should be dealt with outside of the Board of Professional Responsibility.
We'll rely on what's in the brief. Thank you.
Yes.
let's hear from disciplinary counsel. Ms. Porter, you've got 20 minutes as soon as the clock is set. Whenever you're ready.
Thank you. May it please the board, Julia Porter. I'd like to start first with the evidence confirming the hearing committee's finding that there was an attorney-client relationship. Also talk about the other misconduct that the hearing committee found and address some of Mr. O'Neill's recent statements and the statements in his brief. Starting with the attorney-client relationship and the findings of the hearing committee, which are supported by clear and convincing evidence. I'd have you look at no other things than respondents' own written statements during the negotiations. And that is exhibits number 24 through 27 as examples. He refers to Mr. Fusco as his client. He refers to himself as a lawyer or esquire. He writes it on his legal letterhead. The email signature line includes his DC bar number. I think that the board has already alerted Mr. O'Neill to some of the other statements about not committing malpractice. Those emails and letters also indicate that he was providing advice and participating as a lawyer in the negotiations. He referred more than once to his IOLTA account, something that you wouldn't refer to if you weren't acting as a lawyer representing a client. Those are just Mr. O'Neill's, and the fact that he charged attorney's fees or legal fees. That's just what Mr. O'Neill said out of his own mouth. But you also have the testimony of Mr. Fusco and Mr. Walsh, who were dealing with Mr. O'Neill in these negotiations and dealing with him. Well, the circumstances of his hiring was as a lawyer, as an advisor, as a lawyer, and in the negotiation, he acted in that capacity. I mean, it's important for finding the Rule 1.15 intentional misappropriation, but separate and apart from whether or not Mr. O'Neill was acting as a lawyer, he's still engaged in theft and fraud. He produced false evidence to a court. He lied to a court. He lied to disciplinary counsel. He created multiple fraudulent documents, including fabricated bank records. And separate and apart from the intentional misappropriation, his flagrant dishonesty, which the hearing committee outlined in some detail, is sufficient in and of itself to support their recommendation of disbarment. And finally, I'd like to address, unless you had a question, I'd like to.
If I could just for a second,
Sure.
Mr. O'Neill's gone off video. Mr. O'Neill, are you still there? I want to make sure we didn't.
Sorry, I had you muted. I pushed the wrong button. I pushed the wrong button. Sorry.
Apologies, Ms. Porter.
That's fine. I would like to address his representation of today that he is now paid, Mr. Fusco.
Ms. Porter, I do have a question. Following up on one of Mr. O'Neill's points, do not other professions refer to the persons that they interact with as their clients? So simply calling Mr. Fusco his client, you're not suggesting that that alone creates the lawyer-client relationship, are you?
I'm not suggesting that that in and of itself, absent everything else, would necessarily mean that Mr. Fusco was reasonable in believing that Mr. O'Neill, but it is one piece of evidence, and it's not the only piece of evidence. There's a reference to malpractice by IOLTA, referring to himself as Esquire, and everything he's writing is on his legal letterhead where he refers to himself as a lawyer, and he has his DC bar number on the email communications. So that was just one piece of it. And as the board is aware, there's case law saying that even if you don't have a fee agreement, accept a fee, if the client's perception is reasonable, that they're looking to this lawyer as their lawyer to provide advice, that is enough, that has been enough in other court cases to find that there is an attorney-client relationship. And here you have not only Mr. O'Neill's own statements and actions and the fact that he took money as legal fees, but you have the testimony, which the hearing committee credited, of both Mr. Fusco and Mr. Walsh. Yes, Mr. Walker?
Ms. Porter, under the DC bar rules, is there a distinction with a difference between acting as a lawyer and acting as a legal advisor? And if so, what is it? If not, why not?
All I know is the case law says it's the client's reasonable perception, or that's kind of the barometer of whether or not there's an attorney-client relationship. And clearly using the term legal advisor is consistent with someone acting as a lawyer. If he wasn't acting as a lawyer, why did he have the term legal advisor? There's also a piece of evidence that Mr. O'Neill has not represented accurately, in fact, misrepresented, about his relationship with Mr. Fusco's brother, Fabio Fusco, which predated the representation. And in that case, he clearly was acting as a lawyer, not just a friend. And if you look at exhibit number 23, that's the fee agreement that he gave to Fabio, where it's, again, on legal letterhead, talks about client, talks about advance waivers, does everything a lawyer does, including charging legal hourly fees. I would like to get to the,
Ms. Porter, doesn't that cut the other way as well, though, that if he was giving Fabio Fusco this retainer agreement, but did not give the retainer agreement, I'm sorry to, I can't remember his first name, the other Mr. Fusco, who were dealing with his money in this issue, doesn't that then imply that he was viewing this as a different relationship because he did not go ahead and put the retainer agreement? And then a second part of that question is, what do you make of the fact that the agreement with Fabio Fusco was with regard to a transaction involved an American company, and he is licensed to practice here in the United States, at least in 2 jurisdictions?
First off, I'll correct you in that it wasn't representing an American company. It was representing Fabio Fusco and his Irish company. Fabio Fusco being an Irish citizen and his company was Irish. Those were Mr. O'Neill's clients. And the fact that he didn't give Adriano Fusco a fee agreement doesn't in any way undercut Mr. Fusco's testimony, Mr. Walsh's testimony, and Mr. O'Neill's own contemporary statements and actions that he was acting as a lawyer. Indeed, it gave rise to another violation, which the hearing committee found, and that is a failure to provide a written fee agreement, notwithstanding that he later then took, without authority, legal fees from Mr. Fusco's funds. And with respect to the payment of those funds, Mr. Fusco and Mr. Walsh have confirmed as late as this afternoon that they have not yet received a penny from Mr. O'Neill. And this is 4 years after his theft, his admitted taking of Mr. Fusco's funds. So, you know, I'd also note that in his brief to the board, which was filed on June 1st, he said he'd pay Mr. Fusco within a week. That means July 8th. He never paid him. He has been making these false promises for more than 4 years. And not only just the false promises, but creating fabricated bank records and false documents and false evidence, including the affidavit of Mr. Raja, whose story, or, you know, I guess Mr. O'Neill's story has changed each time with the telling, but Mr. Raja's affidavit was also fraudulent, as the hearing committee found. That in and of itself warrants disbarment. Presentation of a fabricated and false affidavit, not only to the Irish High Court, but in these disciplinary proceedings.
Ms. Porter, can I ask, I'm going to switch topics just for a moment on choice of law.
Mm-hmm.
Do we have to address a choice of law issue here with regard to what was occurring in Ireland and the statements that were made to the Irish High Court? And if so, do we, on any of these rule violations, should we be applying the rules applicable in Ireland? If yes, I mean, this is a many-part question, I apologize. And if yes, what effect, to what effect?
Well, 8.5 talks about applying another jurisdiction's rules only in connection with the court proceedings. So a lot of the rules that we've charged, including the fabrication of false documents, the misappropriation of funds, the theft of funds, have nothing to do with his actions before a court. With respect to whose rules applies when he's presenting false evidence in the court and not disobeying court orders and being held in contempt, we cited In re Pelkey. In that case, even though most of the misconduct that Mr. Pelkey engaged in occurred in the California courts, the court nevertheless held or applied the DC rules because Mr. Pelkey was licensed in the District of Columbia, but not in California. And we argued the same thing to the hearing committee, but noted that even if you applied the rules that apply to barristers, those are lawyers who practice before the courts in Ireland, the difference, it's basically a distinction without a difference. The rules governing barristers, the hearing committee laid this out. I'm sorry.
Ms. Porter, I understand your point where you're saying that most of the rules charged did not implicate a court proceeding. However, you did charge the false statements, disobeying an obligation to a tribunal, and then interfering with the administration of justice that went to Mr. O'Neill's activities relative to the hearings and proceedings in the Irish courts. So focusing your argument, dovetailing my question with Ms. Pittman's question, don't those two suggest perhaps that your choice of law would implicate Irish law?
Well, I guess it doesn't make much difference if it does, because as the hearing committee said, in a footnote on page 41, even if you were to apply the Irish rules governing barristers, they also prohibit what was the hearing committee found violated 3.3, 3.4, and 8.4D. That is, you can't make false statements, you can't produce false evidence, you have to obey court orders, you can't engage in conduct prejudicial to the administration. And our court has said in Ray Bernstein and in other cases that there's really no difference between our rules and maybe the rules of another tribunal that arguably may apply. It doesn't make a difference. And I'd note too that the 8.4D violation was not confined to just Mr. O'Neill's misconduct, lies, and false evidence to the Irish High Court. It also covered his misconduct in the dealing with disciplinary counsel, and that is making multiple false and knowing misrepresentations, creating false documents, and presenting those. And as the hearing committee found, he repeated a lot of those false statements during the hearing. So that was also the basis for an 8.4D violation, and clearly in his dealings with disciplinary counsel, the DC rules would apply.
Ms. Porter, does your analysis apply to 3.4C when you're a litigant, not a lawyer, in the matter before the tribunal?
Yeah, and I think that In re Pelkey is another example of the court saying that when a lawyer is acting pro se in a proceeding, the 3 series of rules which govern advocates, those also govern a lawyer who is acting pro se. So a lawyer who's acting pro se, as Mr. O'Neill was during most of the proceedings before the Irish High Court, he can't produce false evidence. He can't lie to the court. That violates 3.3, even though he's acting as a pro se litigant, he's representing himself. And there are a number of cases, not just In re Pelkey, that support that proposition. Unless the board has any further
I have
questions.
one quick question. It's on restitution.
Okay.
So my original question was going to be, assuming for the sake of argument that this results in disbarment, is restitution important for us to include in the order, or is it something that would be taken care of during any sort of application for reinstatement? And then a second part is something that has now come up today, which is given Mr. O'Neill's statements during his argument about the fact that he is perhaps in the process of making payment now, what would you recommend in terms of sort of making sure that the record is clear if payment is in fact made today or tomorrow or soon?
To answer your first question about whether or not the board should include a restitution order or requirement, absolutely. It's very important. Number one, Mr. O'Neill should not even be eligible to petition for reinstatement until he has made Mr. Fusco whole. That's not only paying him the money he stole, but interest. And Mr. O'Neill himself has admitted he also is obligated, indeed under a court order, to pay Mr. Fusco's court costs. It's important also for the client security fund purposes. I mean, Mr. Fusco is not alone in being a victim of a lawyer stealing, and the fact that there is a restitution order is very helpful sometimes for those clients to get reimbursement from the fund. So yes, definitely. I mean, disciplinary counsel requested that at the hearing level. For whatever reason, I think that the hearing committee, it's not that they didn't, they rejected our request, but they just didn't address it. But the board should. Restitution should be ordered. And as far as whether or not Mr. O'Neill makes restitution, as I indicated, as of this afternoon, he has not paid a penny, and notwithstanding his statements over the last 4 years, and including in his brief to the court. If and when he makes restitution of whatever amount, disciplinary counsel would be glad to supplement the record, and I will work with Mr. O'Neill to make sure that the board is aware of exactly how much the client received, and the record can be supplemented in that way. But Mr. O'Neill should be required to make full restitution with interest before he's even eligible to petition for reinstatement. I think that is required if we're doing our duty to protect the public, to protect the courts, and to maintain the integrity of the bar. A lawyer shouldn't be able to steal and then say, hey, but let me back in, or, don't do anything about it. Thank you.
Great. Thank you very much, Ms. Porter. Once the clock is set to 5 minutes, Mr. O'Neill, you can, we're almost there. Mr. O'Neill, you can start your rebuttal whenever you're ready. Thanks. Mr. O'Neill, you're muted. You're muted, sir. Sorry.
Yeah, I'm sorry. I want to start the Raja affidavit. It's not false. Mr. Raja did in fact owe 200,000 euros and had promised repeatedly to pay, and provided an affidavit for me to give to the Irish court claiming that he would pay. Unfortunately, Mr. Raja is not available at the moment, and the original copy of that that affidavit is in my documents in storage in Ireland, which I told the committee, the tribunal, and I don't have a copy. But it was not false, and indeed nothing that I told the Irish court was not true. Not one word of that testimony. Yes.
Mr. O'Neill, as I understand your arguments, you're submitting to the board that since you were not acting in the capacity of a lawyer, the rules of professional conduct do not apply to you. Taking that notion that you have to the charges that the hearing committee found you violated relating to theft and larceny of Mr. Fusco's funds, can you explain to us how you would, if you did take somebody's fund, or if a lawyer took somebody's money, stole it, how is it that the rules of professional conduct would not apply to them when they are a licensed lawyer? So said another way, when you hold an attorney's license, are you suggesting that a licensed lawyer can commit a crime and that would have no ramifications for their license if they commit that crime outside of the jurisdiction where they're barred?
No, I'm not suggesting that. I'm just suggesting that it wasn't a crime. The funds were entrusted to be Mr. Fusco to hold. I agree that I used them for purposes that he didn't authorize, but I have never attempted to or denied that I owed the funds to Mr. Fusco. And it was a private matter between Mr. Fusco and myself in terms of the entire proceeding. None of the statements I made. Yeah. Yes.
So are you, so I can understand this then, are you suggesting that when anyone, whether a lawyer or not, takes someone's money and gives it away to other people, that is not a theft if you plan at some point in the future to give the money back? Is that what you're suggesting? That is not a theft to take someone's money as long as you plan someday?
Yes, that's exactly what I'm suggesting. Mr. Fusco gave me those funds to hold. They didn't give them back to him until recently, But I'm arguing it was not. In fact, the issue was brought by Mr. Fusco to the Irish police, who declined to view it as a theft in Irish law because it was entrusted to me by Mr. Fusco, and it was a matter of contract in their view, not a matter of law. Mr. Fusco improperly stated at the hearing that they said it wasn't enough money, and that's obviously nonsense. Irish, that's a significant sum of money, and Irish grand larceny is anything over €1,000. So it was clearly the Irish police viewed it as basically him having entrusted me with the funds.
So Mr. O'Neill, my question is more of a hypothetical. Are you suggesting that if a lawyer who's barred in the District of Columbia takes somebody's money, regardless of the police's position on that, takes someone's money and uses it to their own purpose, as long as that lawyer intends at some point to return that money, that is not the crime of theft?
I didn't take it. It was given to me, and under Irish law, it is treated as an entrustment, and it was not stolen until I basically refused to pay it back. The inability to pay it back under Irish law is a contractual matter, given the fact that it was given to me not as an attorney, but as a business matter, a business dealing. I never had any intention of not paying it back. And the police in Ireland refused to proceed with the prosecution on that basis. It's irrelevant of whether it's a lawyer or not. I'm saying that on a business basis, it is a business matter. It is not a criminal matter. It wasn't a criminal matter under Irish law. I'm not sure whether it would be a criminal matter under DC law, but it was not a criminal matter under Irish law. It was a contractual matter, and it was dealt with in that regard. It should have been dealt with that way, and it was dealt with that way.
Thank you very much, Mr. O'Neill. Thank you very much, Ms. Porter. The case is submitted.
Thank you.